In this video, we are going to discuss the relationship between the constitutional law and the administrative law. Let us start our discussion with the meaning of the constitutional law. The constitutional law deals with the distribution of power of the state among its three branches, that is legislature, executive and judiciary. Legislature, executive and the judiciary are also known as the three main pillars of the democracy. The constitutional law also deals with the rights and duties of the citizens of the state. In short, the basic structure of the state is called as the constitution of that state. On the other hand, the administrative law deals with the organization and powers of administrative and quasi-administrative agencies. It includes the control mechanism by which these authorities are kept within the bounds and made effective. The constitutional law and administrative law both govern the affairs of the state. As per the early English writers on administrative law, there was virtually no difference between administrative law and the constitutional law, as evident from the definition given by the Kett. According to Kett, it is logically impossible to distinguish administrative law from the constitutional law, and all the attempts to do so are artificial. But still, the difference between the administrative law and constitutional law is observed by various jurists and scholars. According to the Holland, the constitutional law describes the various organs of the government at rest, while administrative law describes them in motion. According to Holland, the structure of executives and legislature comes within the purview of the constitutional law, whereas their functioning is governed by the administrative law. Let us take another statement by Sir Jennings. According to Jennings, administrative law deals with the organization, functions, powers and duties of administrative authorities, while the constitutional law deals with the general principles relating to the organization and powers of various organs of the state and their mutual relationship, and the relationship of these organs with the individuals. There is discussion of two types of the relationships between the organs of the state and relationship between these organs with the individuals. Also, it was said that constitutional law lays down the fundamentals of the workings of the government organs, while the administrative law deals with the details. Whatsoever be the correct position, there always exists an area of the overlap between the constitutional law and the administrative law. The constitutional law confers powers to the executives as well as remedies for the aggrieved person. Hence, the administrative agencies derive their authority from the constitutional law and the statutory law. The legislative authority conferred on such agency is termed as delegated legislation. This delegated legislation is subjected to the judicial review at two stages. First one is a conferment stage and second one is the exercise stage. In the first category, the delegated legislation can be challenged if the essential legislative functions been delegated to the executives or administrative agencies, or if it is ultra vires to the constitution. In Indian constitution, there is judicial remedy such as writ petition, a public interest litigation against the abuse of the power exercised by the administrative authorities. In India, the whole constitutional mechanism for the control of administrative authorities included in Article 32, 136, 226, 227, 300 and 311. Now let us discuss the genus-species relationship between the constitutional law and the administrative law. Administrative law is the law relating to administration. It determines the organization, powers and duties of the administratives. Administrative law tends to deal with the matters as the constitution has embodied the principle of welfare state, and the state can execute and implement these rules in the society only through the administrative law. Hence, Professor Sate has observed that administrative law is a part of the constitutional law, and all the concerns of the administrative law are also concerns of the constitutional law. This constitutional law has a wide sphere of the jurisdiction, with the administrative law occupying a substantive part. In other words, constitutional law can be termed as the genus which of which a substantive portion of the administrative law is the species. Next point we are going to discuss is the watersheds in the administrative law. If we draw two circles by considering the administrative law and constitutional law as two branches of law, at certain place we may find that there is overlap between them, and this area of overlapping may be termed as a watersheds in the administrative law. In this watershed, there is a study of administrative agencies, constitutional limitations on the delegation of powers, and the control mechanism. The study of the administrative agencies are provided by the Constitution under the Article 261, 263, 280, 315, 320A and 324. Directive principles are included under the part 4. Control mechanism on administrative authorities is provided under Article 32, 136, 226, 227, 300 and 311. The administrative law also includes the study of the constitutional limitations on the delegation of the powers to the administrative authorities. It is also provided in the fundamental rights. In this way, we may conclude that the line of demarcation between the administrative law and the constitutional law is very blurred. There is certain area of the overlapping between constitutional law and the administrative law. Rather, constitution is one of the source of the administrative law. There is direct nexus between the constitutional law and the administrative law. Both possess genus-nexus relationship and go parallel to each other.